Hello everyone, my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I'll be discussing one case of Punjab National Bank versus NCLT of Delhi and another's. So in this case, the Delhi High Court has dismissed the petition that was being filed by the Punjab National Bank and its late employee Mr. I.P. Singh, seeking to quash the order of issuance of process under section 482 of CRPC. Further, Justice Malhotra of Delhi High Court has dismissed the two petitions that was being filed by PNB and its former employee under section 482 of CRPC. The petitions were filed seeking to set aside a Patiala House District Court order from March 11, 2019 that summoned the Punjab National Bank CEO and MD and its other employee with respect to commission of offences under section 46 and 47 of Banking and Regulation Act of 1949 with those of under section 120B of IPC. The petition also sought to quash the criminal complaint that was being filed by RBI against under section 200 of CRPC, which is read along with section 47 of Banking Regulation Act of 1949. The present petition was being filed before Delhi High Court in May 2019 by Punjab National Bank in its plea that PNB had evoked the inherent power of the court under section 482 of CRPC to quash the order on issuance of process. By way of a background, the RBI had issued a confidential circular to bank on cyber security control fraud dated on November 25, 2016. The circular also advised bank to explore the straight-through processing between CBS and SWIFT messaging system. It also spoke on trade finance transaction and the misuse of SWIFT fund transferring interference and sent this information in a password-protected form to Punjab National Bank around January 29, 2018. The PNB had alleged that a fraud had been committed and filed a fraud monitoring report and update an application with Reserve Bank of India, which is duly informing them that a fraud of 13,000 crore had been detected at one of the branch of PNB. Following this, a show cause notice was being sent by the RBI to PNB on August 23, 2018, asking them to show a cause in writing as to why penalty under section 47A of clause 1 of subclause C, which is read along with section 46 clause 4 of Banking Regulation Act of 1949 should not impose on PNB. RBI then filed a criminal complaint under section 200 of CRPC 1973, which is read with section 47 of Banking Regulation Act before Patiala House, the Metro Magistrate, seeking prosecution of PNB and its officials for commission of offences under section 46 of Banking Regulation Act, which is read along with section 120B of IPC. A hearing took place in relation to show cause notice on December 21st, 2018, subsequent to which the Committee of Executive Directors of RBI then passed an order under section 47A of Banking Regulation Act imposing a penalty of rupees 2 crore on Punjab National Bank. Finally, on March 11, 2019, the Court of Metropolitan Magistrate of Patiala House Court, New Delhi, then passed an order wherein PNB and other named in criminal complaint by RBI were summoned to appear before the court. The same was then communicated along with the direction to pay the penalty of rupees 2 crore within 14 days of receiving the order. Disagreeing with this decision of the Patiala High Court, the PNB then moved to Delhi High Court for quashing of criminal complaint which is registered against it by RBI and for setting aside of the order dated on 11th March 2019. Then petition was also being filed through Shardul Amarchand Mangaldas and Company. The PNB then submitted before the court an allegation that the RBI had no way indicated which subsection of 46 of the Banking Regulation Act 1949 they were referring to while summoning the bank official and its employee. It was also submitted that section 46 of the Act has a wide-ranging scope. Thus, PNB contends that due to this lack of identification of a particular subsection of 46, a great prejudice has been caused to it. It further contended that RBI criminal complaint and order dated on March 11, 2019 of Patiala House Court was ex officio illegal and ought to be set aside on account of one-sided averments. In its petition, the PNB Bank relied on various judgments of Supreme Court, including Sunil Bharti Mittal versus CBI and Pepsi Food Limited versus Judicial Magistrate. The principles that a summoning order should reflect due application of mind and the magistrate must provide a sufficient basis for proceedings against the accused. The court proceed to dismiss the plea by the PNB. That's all for the day. Thank you.